The answer is yes, a bankruptcy can stop a lawsuit. A lawsuit simply is a party that is alleging through the state, by filing a complaint, that there's something that you've owed them and you haven't been able to pay them. A lawsuit doesn't mean that they win automatically. If someone files a lawsuit against you, it's important, very important, do not let them get a default judgment against you. What that means is, don't just bury your head in the sand, let the 20 days expire, and have them get a judgment by filing a notice of default with the court. Because anything that the creditor alleged in that complaint can be held against you in a default judgment. If they allege that you're a horrible person, or that you've committed fraud, or that you've stolen something, or whatever, if you don't at least defend it on its merits, then they're going to get a judgment against you based on those horrible things that they've alleged that aren't true. Most of the time, what we're talking about in lawsuits are credit card lawsuits or some other breach of contract. And it's important to understand that if just because you've been served with a lawsuit, it doesn't mean that they're going to win. They're going to win if you don't defend against it. But you also have a chance to make them put on their prima facie case, put on their case that shows to the court, to the state, that you owe them something and they can prove it. If they can't prove it, then they're not going to get a judgment against you. Now, remember that it's never too late to negotiate a settlement, whether it's a lawsuit, whether it's already a judgment, whether it's a garnishment in place, even if you've already filed a bankruptcy. It's not too late to to negotiate a settlement with the creditor.